call Martin v. City of Topeka, case number 127715. Counsel, you may approach.
May it please the court, your honors. Chloe Davis on behalf of Troy Allen Martin. And just to reiterate, Chief Justice, I would request 3 minutes for rebuttal.
Thank you.
Good morning, justices. First, Troy Martin would like to thank you for accepting this petition for review. And I would also like to thank you for having me here for the first time. The first issue that has been raised before this court is the conflict between the public duty doctrine and the plain language and purpose of the Kansas Tort Claims Act. The district court, this issue was presented to the district court and it went unaddressed in the district court's ruling on summary judgment. This issue was raised to the Kansas Court of Appeals, and although briefly discussed, they did not rule on the merits of it, basically finding that because it has never been so held, that they would not so hold. I would like to raise it to this court so that it could be ruled upon and discussed by the Supreme Court. As this court is well aware, prior to the passage of the Kansas Tort Claims Act, Kansas adhered to common law principles of sovereign immunity. However, with the passage of the Kansas Tort Claims Act, it has been frequently observed that liability is the rule and immunity is the exception. However, appellant's argument is grounded in well-established universal principles of construction. It is universally accepted by this court that the legislature has the power to abrogate or modify the common law. In fact, to some extent, the Kansas Tort Claims Act has codified the concept of the public duty doctrine. The public duty doctrine, as this court is aware, essentially states that where the duty is owed to the public at large, and if the plaintiff cannot establish a special relationship or a special duty owed to that individual, that liability will not lie. The idea of the public duty doctrine was codified in the Kansas Tort Claims Act at KSA 756104N, which addresses liability in terms of police and fire protection and the delivery of that protection.
Can I ask you, counsel, that I understand your argument is sort of questioning the public duty doctrine in all of its applications after the Tort Claims Act. But is there another path that you've laid out for our court that this, in fact, is a special duty that exists for cities across the state of Kansas, that is to maintain their roadways that they've chosen to open in a reasonably safe condition?
Thank you, Justice. Yes, it would be our position that this duty is a special duty. It's well established in case law that any municipality's duty to maintain the roadway is, and we'll get to this argument later, but it is not discretionary. There is a duty there to maintain the roadway. And even at common law, that duty was one that generally municipalities did not enjoy in terms of common law immunity in general. And so then when you look to the Kansas Tort Claims Act, in light of the backdrop of common law, even the idea of maintaining the roadways was not an immunity that they enjoyed.
Because one of the complications that at least that I think we would have to address to take the larger step on public duty to say that Tort Claims Act sort of recodified that and this duty no longer exists at common law is part of the Tort Claims Act. Provisions say that it's the statutory exceptions to liability are neither exclusive nor to be read as a waiver of immunity from other contexts. And it sort of suggests that there may be other immunity provisions outside of the Tort Claims Act. How do you respond to that subsection?
Thank you, Justice. I would respond with basic interpretation, construction concepts of the fact that the list of exclusions does already codify the concept of police and fire protection, which is traditionally what the public duty doctrine is discussed in the context of. Additionally, the intent of the legislature would govern, as this court knows, and the express plain language of the statute is that if a private person would be liable for the underlying fact pattern, then the government should be liable for that same fact pattern unless it is excluded by the exclusions. And so the argument would be just based on standard construction concepts that had the legislature intended to include it, they would have, and that it's already been codified in the provision, the exclusion that's already there. Additionally, the Public Duty Doctrine and the Kansas Tort Claims Act conflict in terms of the purpose of the KTCA. As I've mentioned several times in briefing and in oral argument, the purpose of the KTCA, as it's been recognized, states that liability is the rule and immunity is the exception. By the very operation of the Public Duty Doctrine, liability is the exception. The very first hurdle is establishing that there's a duty owed to that particular plaintiff that flies in the face of the very purpose of the KTCA.
Can I stop you there and delve a little bit into that? And I want to, the sort of premise of my question is to ask whether or not you think KSA 75-6103A, which is the section we're talking about, is ambiguous or not.
I do not.
And okay, I thought that would probably be your answer, but that's just the sort of the premise of my question. And what I really want to delve into is when it says that the government is liable if a private party would be liable, couldn't that be read two different ways? It could be read to mean we are waiving sovereign immunity in these kinds of cases, or it could be read to mean that we are imposing upon governments the identical duties that are imposed by common law on private people. And so which of those is it? Is it both?
The first answer to your question, Justice, is that it is the first, but if it is the second, I think that the argument then would be that even if they're placing the same duties, so the same elements of negligence, duty, breach, causation, damages, that when you are evaluating the negligence of a private party and you're looking at a duty, you do not first ask, do they owe this duty to the public at large?
Well, right. So in other words, your argument is that 75-6103 does both, right? It both waives sovereign immunity and it imposes by statute all the duties that a private party would owe upon the government.
Yes, Justice, and I believe
that's essentially, I think I'm saying the same thing as we should abolish the public duty doctrine.
Yes, Justice, I agree. And then additionally, I think that's how you lead into that if you are going to apply the public duty doctrine, there are exceptions, and one of those exceptions applies here. So should the court decide to apply, that's where you lead into possessor license.
This is my last question in this line of questions. What would you point to in the statute itself that would suggest that that's the proper way to interpret this language? I'm just thinking purely in terms of statutory interpretation.
Your Honor, I think the plain language of the main operative provision where it references a private citizen, and I can give you the exact statutory citation if you would like, but we can see that there is no other provision of the statute that says when we typed a private person, this is what we meant. But based on standard statutory construction, it would be our argument that the plain language would control, and the plain language says a private citizen. The second issue that has been raised before this court is that in the event that the court should not abrogate the public duty doctrine, as I mentioned briefly, that there is an exception that applies here, and that exception is that of a possessor licensee. I understand that this is a creative argument. Nonetheless, we argue that it does apply here. The city of Topeka requires that individuals have driver's licenses in order to navigate the city's roadways legally. It is my understanding that if you do not have one of those, you will get ticketed if you are stopped by a city of Topeka police officer. And so therefore, this possessor licensee relationship should create an exception to the public duty doctrine should this court continue to uphold it. The Court of Appeals on that point pointed out that it's the state of Kansas that issues driver's license as opposed to the city of Topeka. The counter argument that we would have to that would be that it is still the city of Topeka that requires a driver's license regardless of who issued the license.
But the duty's not just owed to drivers, right? I mean, it's pedestrians, bicyclists. So how does that affect your argument? about licensing, making it a more specific duty?
Justice, the argument would be that the public duty doctrine should not apply for that very reason, is that this exception, so under the argument that there's a special relationship.
Right. I mean, this all is premised on public duty doctrine existing. I understood that to be
Yes.
your argument that you could still prevail under this licensing argument.
Yes.
Yeah.
So under the argument, pedestrians and people not navigating, well, actually, I believe that people navigating like motorized bicycles also have to have some type of licensure to do so. But for pedestrians who are on foot, then they would not have a special relationship with the city under the doctrine. One point that I would like to make, justices, is that both the district court and the appellate court relied heavily on BNSF, the BNSF case, which is BNSF versus the city of Augusta. And I would like to point out some distinctions between the facts before that court and the facts currently before this court. First, in the BNSF case, there was the National Electric Safety Code, which did impose a specific discretionary element to the cities to inspect the power lines at issue. So it was expressly left to the cities to do that. Additionally, no complaints had been received about the power line at issue in the BNSF case. Here, the city had received upwards of 35 complaints about this specific stretch of roadway. Particularly less than 4 weeks before Mr. Martin's accident, they had received a complaint expressly about both the north and southbound lanes of this exact block. And on average, it took more than 4 weeks for the city to fix any given pothole. So we would just like to draw those two distinctions between the BNSF case and the facts currently before this court. And justices, I see that I have a few seconds left. I'm happy to answer any additional questions or hit my third and final point.
So is it your argument then that the duty to maintain the street does not become, it's not discretionary because of the constructive notice or the fact dispute about constructive notice?
Yes, Justice, I think we have several different veins of argument about why it's not discretionary, whether it be under common law principles or under the KTCA principles. But yes.
I mean, our cases of, I mean, almost going back to statehood have described this city's duty to maintain streets as being mandatory. But then, you know, more recent cases have said, well, not all legal duties can be framed as mandatory. There has to be some sort of trigger. I'm just trying to understand, how do we read those two cases together? Otherwise, you know, discretionary function immunity would never apply because you're always alleging a duty existed that was breached.
Thank you, Justice. I think one thing that might illuminate this point is under discretionary function immunity, such as the BNSF case. So, for example, there were the factual elements present in that case where discretionary immunity makes sense. Here, there are not. One, there is an actual statute that says that the city has a duty to repair and inspect the roadway after a storm and as soon as possible upon complaint. And so here the argument would be that complaints were made and an inspection was not performed as soon as possible thereafter. The second would be under common law. Even under common law principles of sovereign immunity, the duty to maintain the roadway was not one that was not an immunity that was enjoyed at that point either.
Any other questions, colleagues? Thank you.
Thank you, Justices.
May it please the court, Nick Jefferson appears on behalf of the city of Topeka. Thank you, justices. Obviously, you kind of know the background and the facts of this case, so I won't go into any of that. I'll just jump right into the two issues that we're talking about today. The public duty doctrine primarily, or at least first. And I think there's a distinction to be drawn between sort of what we're talking about here. The Tort Claims Act and those exceptions are exceptions to liability. the public duty doctrine has to do with the establishment of one of the elements of negligence, and that's duty. So that's sort of the first initial step that you need to look at least pursuant to the current case law.
So I'll jump in right here and ask you the same question I asked the opposing party, because it's directly relevant to the point you just made, which is 75-6103A ambiguous? Because the plaintiff argues that that statute imposes all of the private party duties on the state or on the public entity. That's the argument from the statute based on the language. Sorry, I'll pull it up. That, and we're familiar with it, that you're liable under circumstances where the government entity, if a private person, would be liable. So what do you think that statutory language means?
Thank you, Your Honor. Yeah, I don't believe it's ambiguous at all. I think it says, it jumps right to liability. The statute says, that liability applies the same way it would to a private.
So your argument is that the plain language of this statute functions only to strip away sovereign immunity.
Correct.
It's not a sort of imposition of private party duty on the government.
Yeah, correct, Your Honor. I don't read it.
My question is the same. It's like, just from a statutory construction or interpretation perspective, how do we get there? In other words, both sides have said this is plain language and with opposite meanings. I'm going to suggest that perhaps this is an ambiguous statute. And if it is, how should we go about resolving that ambiguity?
Well, I think, again, the statute presupposes that we've already gone through the steps of establishing there's liability. The public duty doctrine addresses one element of the finding of negligence. So it treats the city, the public duty doctrine treats a city different than a private individual. And insofar as
there are different duties. I mean, that's the whole puzzle here, is that this statute, it seems to me, can be read to suggest that by statute, the legislature was imposing on government entities the duties of a private citizen, which would in fact eliminate the public duty doctrine.
I think if it was read that way, yes, you are correct.
So why shouldn't we read it that way?
Because I don't believe duty is addressed anywhere in the statute.
Okay, that's not really a principle of statutory interpretation, though. Like, is it that we should consider the statute as a whole, and that the thrust of the statute as a whole is to strip away sovereign immunity? I'm just trying to get a sense as to how you would argue to us that we ought to construe this statute using our tools.
Correct. Well, I don't think anything in the statute does anything to what exists for the analysis of negligence itself. And that's sort of what I would argue. And I think essentially the difference is the public duty doctrine is saying that the duties may be different between a government entity and a private individual. And that sort of makes sense to me, because cities engage in different activities than individuals. No individuals I'm aware of, operate miles and miles of public streets. So you have to go through that initial duty analysis. Now, to the question of liability, and especially the exceptions to liability under the Torts Claim Act, that is the legislature specifically saying there may be liability in certain cases, but we've decided for policy reasons that even if there is liability and it holds against a city or a county or whatever, that we are going to accept that. We're going to give immunity for these certain instances. I guess the way I reconcile that in my brain, again, is just in one case you're doing the analysis of whether or not there is negligence. In the other case, you're saying doesn't really matter how that analysis comes out. If there's liability, there's an exception, or if there's not an exception, there's liability. So I guess that's how I would reconcile that, Your Honor.
But under the text of subsection A, I guess I wonder why would a governmental entity need immunity at all if the duty ran to a private person ordinarily, right? and subsection A seems to suggest that there is in fact liability for acts or omissions or damages caused by negligent or wrongful act or omission of an employee if a private person would so similarly situated also be liable.
Yes, Your Honor.
If you, I don't know if you understood that question. It's textual, I guess.
Yeah.
I mean, what purpose would this subsection serve? I mean, I guess I'm wondering, like, why would, if the government weren't liable for duties that a private person has in the first place, what's the purpose of subsection A?
I think the purpose of the act is to establish that there is liability for a city in those instances where the private individual would be liable.
But they could, I guess my point is, could they be liable if they didn't have that duty in the first instance, they being the governmental entity?
No, Your Honor. No, I don't believe if you can't get across the question of whether or not if there's no duty, then you can't get to negligence, which means there's no liability.
Right.
So you don't need an exception in that case. That would be my argument on that. And in regard to the, I guess the second argument, even if the court were to decide that the public duty doctrine doesn't apply.
Before you move on to discretionary function immunity, let's talk about this duty that's like really does trace back almost to statehood. This duty that was imposed on cities, and in some of the earlier cases, they make clear that the city is not obligated to open a street, right? But once it does, it has the power to assess and maintain those roads, and comes with that a duty to keep that road safe for its intended purposes. Why is that I mean, that seems like a duty that's more specific, or at least different in character than in law enforcement, that sort of a more amorphous duty to maintain the peace. Right, we're talking about a duty that applies to cities, that attaches only once it chooses to open a road, and the scope is limited to users of that open road.
Correct, Your Honor. I think there is absolutely a general duty for a city to maintain its roadways in a reasonably safe condition. But I think it's analogous in a certain way to, I realize the public duty doctrine, at least in Kansas, has typically been applied only in law enforcement activities or maybe some social services, which is why the exceptions, two of those have to do with custody, custodial. But I do think it still applies, the reasoning for why the public duty doctrine exists still applies. And that being that essentially, the doctrine itself, it protects government entities from just unlimited liability exposure from again, it goes back to that point that a city is different than a private person. The city maintains a vast network of roadways. I think if the city does have notice of a specific road defect, I think that changes the argument. But this general duty to impose a general duty on a city that if anytime anyone ever hits a pothole, that the city is somehow liable, I think it would just create a situation where I don't know how cities could maintain those roadways in such a manner, in a cost-effective manner. The underlying principle, I think, is still the same. You have a municipality, a government that's in a different situation than a private party necessarily would be. So I do agree that typically the public duty doctrine has been primarily just used for law enforcement activities. However, I do think the same logic that applies in those cases applies when it comes to something as vast as maintaining a street network. Finally, I'll move on to discretionary function. The city also argued that, if the public duty doctrine doesn't apply and there is a duty in this case, or if it does apply and for some reason a special duty does apply. The city is still immune from liability under discretionary function immunity. And the city based its argument on this basically for two reasons. And one is that while we do recognize the city has a duty to maintain its streets in a reasonably safe condition, the manner in which it does that is discretionary. To the point that, and that goes from, we've argued that it goes from how the city receives notice of potholes, because that has to do with the city balancing its limited resources. We don't pay people to just drive around looking for potholes. And the second being just the decision of how it maintains and repairs its streets. And that, we go into a lot of argument in our brief about, what constitutes just this road getting a few pothole repairs here and there with cold mix versus what goes into complete deconstruction and rebuilding of a road. That has to do with engineering expertise. It has to do with the finances available. Those are decisions that get made all the time. We speak almost every week at city council about our budget. Go ahead.
Excuse me, I don't understand your argument about notice.
Okay.
Then, because it seems to me extending or applying what you just said, that notice doesn't matter. If you know that there's a pothole, a big old pothole, you're going to say, well, we still have discretionary immunity because how we allocate our resources is up to us. And so, yeah, there's a hole, but there are other holes and we ought to.
Yeah.
It seems to me that there's never a circumstance, if we take everything you're saying to heart, that the city would ever have liability. But I wrote down that you said if there's notice, that's different. And I'm not beginning to see an end, I don't see liability at the end of any of these paths, the way you're looking at it.
No,
That makes sense.
It makes sense what you're saying. I do think there could be liability if there's actual notice of the pothole and the city fails to address it.
But then you're just going to say, oh yeah, but we had other potholes and we decided to go fix them.
I don't think that would be the case. I think if you're put on actual notice of an actual defect, the duty would be for a city to come in and fix that actual defect. I think what the difference we have here is there was no actual notice of this particular pothole. So we are sort of in the realm of constructive notice, which I don't think we had constructive notice of this particular case, but I definitely don't think we had specific notice of this specific pothole.
Well, the panel found that there was a fact question on constructive notice, right? And there's no cross petition. That's what we're dealing with at this stage, right?
But yeah, but the panel also found that the city's method of receiving notice was discretionary and that the city did not.
Right. I'm just on the simple question as to whether or not the city had constructive notice. That is, at least the panel held of that's a fact dispute. They didn't say that changed the outcome, right, of summary judgment, but that was, they found the trial court erred because there was a fact dispute as to constructive notice, right?
I believe they did find that in the section on breach. Yes, Your Honor.
Right. Now, if we look at the cases interpreting this duty, they've always framed it as a mandatory duty when there's actual or constructive notice coupled with reasonable time to fix the defect in the road. Is that the test then to really assess whether the duty in question is mandatory or discretionary? Or has something changed over time that makes that case law no longer applicable?
No, I don't think anything has changed, Your Honor. I think actual notice certainly would compel the city to take some type of action in a reasonable amount of time. And I think you could get there also potentially on the constructive notice argument as well. I do think one of the arguments in this case, well, not the argument in this case that the plaintiff eventually pivoted to was that the road was in such a state of disrepair that the city should have known. And one of the arguments that we had on that was there's no evidence presented in the record that other than plaintiff's own assertions that this road was in complete disrepair. And so the city should have known. We don't have that evidence in the record. There's been no experts in this case, anything to that degree. So I do think, to your point, I don't think we're upending a lot of case law here in this particular case. I think if there was notice and the city failed in some way, that could lead to liability. It looks like I'm out of time. Anyone has anything else?
Any other questions, colleagues? Thank you very much for your argument. Yes. And you did reserve 3 minutes.
Thank you, Justice. Chief Justice. Justices, I would like to, may I begin?
Yes. Oh, yes, yes.
Apologies. Okay. I would like to address a couple of points that were made. First, Justice Wall, to your point about the common law duty going back almost to statehood, I would like to bring up, it's touched on briefly in the petition for review, but the idea of the policy considerations that would go into continuing to shield municipalities from this type of liability. If there is an ongoing issue with the condition of the roadways and the courts were to find that in any avenue that we go down, there's no liability for injuries that are caused by the condition of the roadway, that there are considerable policy issues based on that decision, if that were to be the decision. The second thing that I would like to touch on is counsel's statement that if the city had noticed, that it changes the argument, and we agree. And we would like to point out, as Justice Wall also pointed out, that the Court of Appeals did find that to be a fact question based upon the facts that were presented in the summary judgment briefing at the district court level. And the way that that matters is that it impacts the discretionary function analysis under the KTCA. Because if they did have notice, and this was one of the early issues with the argument, is that if there is a pothole on one part of the road, and then there's a pothole 3 feet away, and they have notice of one pothole, but not notice of the other pothole, the argument is going to continue to be, well, we had argument of this pothole over here, but not the one 3 feet away. So we'll handle liability over here, but not over here. And we would just raise that point to the court. And then lastly, in terms of the point that was made about expert testimony, it was ruled upon by the Court of Appeals that expert testimony would not be necessary here in terms of really any analysis. I think, in fact, people who are daily drivers of the city of Topeka roadways might be experts on the condition of those roadways. And so therefore, if the fact question was presented to a jury on whether or not this the condition of this roadway was handled appropriately, the jurors of the city would be appropriate to answer that question.
Under your Tort Claims Act argument that it does away with the public duty doctrine, then wouldn't that mean that sort of gets rid of the city's duty to maintain streets? We would more look at what the duty of a private owner would be. Is that how you would frame the duty question if your statutory argument is correct? What would the duty be of a city? That of a landowner, or?
Yes, Justice, I think that would be the theory, would be that a private person does have a duty to maintain the premises that they own. And again, this is where you kind of lead into the exceptions to the public duty doctrine about possessor or licensee. I think it's entrenched in those same concepts of that private landowners do have that duty, that if they have a dangerous condition on the premises, they have a duty to address it.
Does it make sense, and this gets back to my ambiguity question, does it really make sense to impose on a government entity the duties of a private citizen? Because they really are so differently situated.
I think it does, Justice. I think it makes plenty of sense. One being that that's what the statute says, and two being that taxpayers are paying the government entity to operate appropriately as the legislature sees fit. And so because the legislature passed the KTCA, that sovereign immunity was stripped by that passage.
Any other questions, Gordon? Thank you very much for your arguments this morning.
Thank you, Justices.
Court will take this matter under advisement.